turn, May. All right.
All right, thank you. Please be seated. All right. Can the interpreter hear me?
Yes, Your Honor.
Okay. Good morning. All right, this is the 11 a.m. initial appearance calendar for May 23rd, 2025.
Este es el calendario de la comparecencia inicial 23 de mayo a las 11 de la mañana.
The court's orders for the taking of fingerprints and DNA samples made on the first calendar of the month will also apply to these hearings.
Las órdenes emitidas con respecto a las de huellas dactilares y de ADN emitidas el 1 del mes en todos los casos.
With Mr. Jaramillo, Libardo Jaramillo, if you please come all the way to the podium.
Señor Jaramillo, pase al podio.
Good morning, sir. May I have your full name and your date of birth, please?
Libardo Jaramillo. Oh.
Señor,
go ahead and
¿necesita
ask
usted
him.
intérprete?
Sí.
Ok, su nombre completo y fecha de nacimiento.
Libardo Jaramillo, septiembre 3 de 1971.
Librado Jaramillo, September 3rd, 1971, Maria Court, Court Interpreter's Office.
All right, thank you. Sir, you have been arrested on one allegation of disorderly conduct with a deadly weapon. That's a Class 6 felony.
Señor, usted fue arrestado por conducta desordenada con un arma mortal, es delito categoría 6.
There is probable cause for that offense, and I am appointing a lawyer to represent you in this case.
Existe motivo fundado en ese delito y le asignaré un abogado para que lo represente.
Your next court date will be a status conference on May 30th at 8:30 in the morning in the downtown Superior Court.
Su próxima audiencia será una audiencia de repaso el día 30 de mayo a las 8:30 en el Tribunal Superior.
Your preliminary hearing is scheduled for June 2nd at 8:30 in the morning in the same court.
Su audiencia preliminar está fijada para el 2 de junio a las 8:30 en la misma sala.
The address will be on your paperwork.
La dirección estará en sus documentos.
You have a $2,500 secured appearance bond in this case.
Tiene una fianza para asegurar su comparecencia de $2,500.
You have other conditions you're ordered to comply with, which include the following.
Tiene otras condiciones con las que deberá de cumplir, que incluyen las siguientes.
You may not have any contact with the alleged victim.
No deberá de tener comunicación con la supuesta víctima.
You may not possess any weapons.
Tampoco tendrá posesión de armas.
You may not possess or consume any alcohol.
Tampoco tendrá posesión y consumirá bebidas alcohólicas.
And you may not drive without a valid driver's license.
Y no se le permite manejar si no tiene licencia de manejar.
All right, everything else will be in your paperwork. If you step to your left, he's going to give you a copy. Thank you.
Todo estará incluido en sus documentos. Pase a la izquierda para que recoja su copia. Gracias.
Thank you.
All right, can the interpreter make a general call for me?
Yes, Your Honor. ¿Alguien más necesita intérprete en español? Si es así, levanten la mano. Any hands?
Will you guys look? No hands? Okay. All right, looks like we're good to go. Have a great day. Thank you.
Thank you.
All right, let's continue with Christopher Lopez, please. If you come all the way to the podium. Mr. Lopez, after that, I need Isaac Bafford to please go to the chair just inside the door. Mr. Bafford, there's a chair just inside the door if you wait right there. Hello, sir. May I have your full name and your date of birth, please?
Christopher Lopez, 11/19/1982.
Thank you. You're here on, 4 probation warrants that issued in each of your 4 cases. On May 21st of this year, after you failed, well, no, I'm sorry, I thought you failed to appear. No, supplemental petitions to revoke were filed in your cases, meaning now there's a second petition pending in each of the cases. That second supplemental petition alleges that you violated terms 3 and 5. You will get a copy of it from your lawyer, and I am appointing a lawyer for you on these petitions as well. It's going to be the same person that's already handling your other pending petitions. Your next court date for all 4 cases will be May 29th, this Thursday at 8:30 in the morning in the Downtown Probation Court for a revocation, arraignment, and possible disposition hearing. This court finds that you will, in all reasonable probability, suffer a term of incarceration in one or all of these cases. For that reason, you are held without bail in each of these 4 cases. You'll go to court next week, and you can speak to your lawyer at that time. If you'll step to your left, the officer is going to give you copies of your paperwork. Mr. Bafford? And Carmen Castro, we go to the chair. Good morning, sir. May I have your full name and your date of birth, please?
September 25th, 1997.
I'm so sorry. I cannot hear you, sir. Can you lean forward a little and speak up?
Isaac Bafford, September 25th, 1997.
Okay, thank you. You are here on a total of 3 matters. One is a newly charged case. The other 2 are probation warrants. I'm going to start with the newly charged case. You have now been formally charged in a criminal complaint with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. The alleged offense date for these is December 28th of last year, 2024. I am appointing a lawyer for you in this new case. I'm also appointing a lawyer for you in your 2 probation cases because there were warrants out for your arrest in both of those cases after petitions to revoke your probation had been filed back on April 24th of this year. The petitions to revoke allege that you violated terms 3 and 5. All right, you are going to go to probation court first for both of those cases. That's going to be May 29th, which is this Thursday at 8:30 in the morning for a revocation arraignment and possible disposition hearing. In the new case, you're going to go for a status conference on Friday, May 30th, 1 week from today at 8:30 in the morning, followed by a preliminary hearing June 2nd at 8:30. And in between those, which will be the afternoon of May 30th, so 1 week from today at 1:30 p.m., you're going to have a bail eligibility hearing in the new case only because you are not eligible for bail today. There is probable cause for new felonies that are alleged to have happened before you got sentenced in your probation cases. They remained open and pending on December 28th of 2024. So the alleged date of crime in the newly charged case, which is December 28th of 2024, at that moment in time, you had both of those cases were pending. You had not yet been sentenced So that triggers a no bond law, which means I must hold you no bond at this hearing and give you a bail hearing. So your bail hearing is in 1 week, the afternoon, May 30th, 1:30 p.m. Your lawyer will meet with you in the morning, explain to you what's going to happen at the bail hearing in the afternoon. You may or may not be found eligible for bail in a week, but you are not eligible today. In each of your 2 probation cases, you have a $750 secured appearance bond. That's $1,500 total with written release conditions. But you shouldn't try to post those bonds so long as you're still being held without bond in the new case, because you wouldn't actually get out. So you should have the same lawyer for everything, and you can speak to your lawyer about your overall situation next week. Just step to your left, the officer will give you your paperwork. Thank you. Ms. Castro, or Mr. Castro, Carmen Castro. Looks like it's Ms. Castro. After that, Cody Miller, will you please go to the chair?
Morning.
Hello, ma'am. Can I have your full name and your date of birth, please?
Carmen Coronado Castro. My date of birth is September 27, 1989.
All right, thank you. Ma'am, you're here because you have been charged in a criminal complaint with 1 count of, dangerous drug possession. Let me make sure we got that right. Yeah, we did. Okay. Dangerous drug possession, a Class 4 felony, and drug paraphernalia possession, a Class 6 felony. The alleged offense date is February 4th of this year. I'm appointing a lawyer for you. It should be the same person that you have for your other open case or cases. Looks like you have several. The one that is important in this case is CR 2025-104-104, because your initial appearance date in that case was January 27th. The alleged offense date for these is, I'm going to double check, because I think I just said February 4th, but this says March. It's February. So approximately a week after your initial appearance in the case number I just recited, you're alleged to have committed these offenses, which triggers the no bond rule. I see you have been through this before, so I won't overly explain it to you. All right. So I am appointing a lawyer for you. You should end up with the same lawyer for everything. Your status conference in this case is going to be this Friday, May 30th at 8:30 in the morning. In the afternoon, you'll have your bail eligibility hearing. That's at 1:30 p.m. on the 30th. Preliminary hearing June 2nd at 8:30. And pursuant to Arizona law, you are held without bail today. As I noted, you may or may not be found eligible for bail next week, but you're not eligible today. All right, we're going to get you that paperwork, and you can step out to your left. Thank you.
Thank you.
All right, Mr. Miller. After that, Lee Hernandez. We go to the chair. Hello, sir. May I have your full name and your date of birth, please?
Morning, Your Honor. Cody Scott Miller, and then March 27, 2006.
All right, thank you, Mr. Miller. You're here on a new case. You're arrested for allegations of possession of narcotic drugs for sale, a Class 2 felony, 2 allegations of possession of dangerous drugs, 1 allegation of possession or use of a weapon during the commission of a drug trafficking crime, 1 allegation of possession of marijuana for purposes of sale, and 1 allegation of possession of narcotic drugs. All of those are Class 4 felonies. Finally, simple possession of marijuana in violation of law, which I presume is by age, and that is a Class 6 felony. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you. Your next court date is the status conference, May 30th, which is this Friday at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing June 2nd at 8:30 in the same court. Based on what has been alleged against you, the court sets bail in the amount of $10,000. It is secured. Secured means you can use a bail bond company. If you bond out, you will be on an electronic ankle monitor with a minimum curfew of 10 p.m. to 6 a.m. unless otherwise authorized by pretrial services, as noted in my order. You may not possess any weapons, no drugs without a valid prescription, no alcohol. I'll note the state requested a $50,000 secured appearance bond. That is because there appears to be substantial evidence that you were a drug dealer, an armed drug dealer. And so, Mr. Miller, if you post bond, take your release conditions very seriously. The case that you were released on recently, that is not gone. They just did not formally charge it right now. There is a 7-year statute of limitations on felonies in Arizona. So if you think Hello, sir. May I have your full name and your date of birth, please?
Roman Gabriel Garcia, April 21st, 1993.
All right, thank you. You're here on 3 things. 1 is a new case, 2 are warrants. In the new case, you were arrested for assault as a Class 3 misdemeanor. There is probable cause for that, and I am appointing a lawyer for you. Then you're also here on a warrant That is number 3 on the calendar from the Goodyear City Court, where you've been charged with assault and disorderly conduct, both as Class 1 misdemeanors. Finally, you're here on a warrant from the White Tank Justice Court, which is a post-conviction warrant in a shoplifting case. It's a Class 1 misdemeanor, and you have already been convicted in that case. All right, starting with the new case in Buckeye, your arraignment hearing is going to be May 28th, which is this Wednesday at 1 o'clock in the afternoon in the Buckeye City Court, and you have a $500 secured appearance bond in that case. That is the same date and time we're giving you for your Goodyear City Court case. So I'll tell you what to do in a moment, because I cannot change court dates for the city courts. So your Goodyear City Court date, this is in the failure to appear one, the assault and disorderly conduct case. And that is going to also be May 28th at 8:30 in the morning. But in the Goodyear City Court, you also have a $500 secured appearance bond in that case. So that's $1,000 total. If you bond out, you need to pick one of those courts and call them, because you can't be in 2 places at once. If you're still in custody, the sheriffs are going to take you to one, and they will tell the other one to move their court date, that you're not available for transport. So the sheriffs will take care of it if you don't postpone. If you do postpone, you have to take care of it, because you're going to catch a warrant in any court that you don't show up in. Now, in the new case, that's going to be Buckeye City Court. And guess what? It is the same date. It's not the same time. So it's going to be an arraignment hearing in Buckeye City Court, May 28th at 1 in the afternoon. If you're out of custody, I doubt you can make it to that. If you're due in one court in the morning, you could very well be late for Buckeye. So you should try to get both of those court dates moved if you can. In any event, in the failure to pay case, that's the shoplifting, I'm just setting a $50 placeholder bond, because that's not a failure to appear, it's a failure to pay. So your total bond for all 3 cases is $1,050. It is secured. If you bond out, comply with all of your written release conditions. Looks like, I think you are also on probation, as I recall. You have to call your PO within 72 hours. You are on probation of release. Yes, I factored that in.
I wanted to ask, because I had the Goodyear failure to appear warrant quashed on April 21st with the judge in Goodyear. I went to that court date for probation for a bond revocation, and the judge in Goodyear said that she would quash that failure to appear warrant because I missed that case.
Well, I'm sorry to tell you, I have no way to tell that from Goodyear. You know, the most I'll do is I'll ask my staff to look it up in public access. We may or may not be able to see something in public access that would corroborate that. I don't take people's word for that sort of thing, especially not when you've got an open felony and you're actively in the probation violation process. So if we can see it, then about all I would do is, I mean, even if I release you in the Goodyear case, you still have to post the other bonds.
Well, that'd be $500 less.
Indeed, I agree. So we're going to see if we can confirm any of that in public access. If we can't, then you're going to have to go deal with the Goodyear court on that. You will get credit for time in that case. Everything's going to be on your paperwork, though, so go ahead and have a seat. We're going to have her look it up. I'll keep moving, and I'll just let you know. If I am going to change what I'm doing, I'll call you back in here. If I'm not, I'll just let you know.
Thank you.
All right, thank you. Mr. Arnold, Bradford Arnold. After that, Lachey Ralph, will you go to the chair? And that was, what was that one, number 3? Okay, thank you. All right. Hi, Mr. Arnold, can I have your full name and date of birth, please?
Bradford Arnold, 6/15/94.
Okay, thank you. You are here on 3 things. 1 is a new case, 2 are probation holds. In the new case, you got arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer to represent you. I'm also appointing a lawyer in both of your probation cases, because the probation department is going to file petitions to revoke in both of your probation cases, so you need a lawyer, and you will have one. And your revocation, arraignment, and possible disposition hearing in those probation cases, that's going to be your first one. It is this coming Thursday, May 29th at 8:30 in the morning. That's for both probation cases. The next day, May 30th at 8:30, you'll have a status conference in the new case, followed by preliminary hearing June 2nd at 8:30 in the new case only. In each of your 2 probation cases, your bond is $250 secured. In your new case, it is $50 secured to make you eligible for credit for time in custody. It is $550 total. If you do bond out, comply with all of your conditions, call your PO within 72 hours. You've got your paperwork.
Thank you.
Sure. Just give me 1 second, ma'am, okay? Okay, will you do me a favor? What I'm gonna do is, I'm gonna release him, and I'm gonna know, I think what I wanna do. Pretty good, all right, I'm gonna know actually, but I do want that attached. Okay, all right, thanks. And don't take out Roman Garcia. Where's Roman Garcia? Is he, okay, stay there because I can see it. I can see that it was quashed. So I'm just gonna no action that, but I want you to end up with the order, okay? All right, so if you guys can leave Roman Garcia in here, I still gotta do that. All right, ma'am, can I have your full name and date of birth?
It's the same, Ralph, 10/25/89.
Okay, thanks. You're here on an arrest warrant for an older case. You have now been formally charged in a criminal complaint with possessing narcotic drugs, a Class 4 felony, and theft or control of a stolen credit card or obtaining a credit card by fraudulent means. That's a Class 5 felony. The alleged offense date for both of these is November 7th at 2023, and it looks like this comes out of the Phoenix Police Department. So I am appointing a lawyer for you. Your next court date is going to be in 2 weeks. It is June 6th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing June 10th at 8:30 in the same court. Now, in this case, the state originally requested a summons for you, and we just didn't have a working address. That's the only reason it turned into a warrant. You do have criminal history, and not a little bit. You have a fair amount of criminal history, but the state only ever asked for a summons. This is a property case, and it is not new. So I'm going to give you a chance on supervised release. I want you to report to pretrial services.
Thank you.
Don't have any contact with any alleged victims in this case. Don't go to the scene of any alleged crimes. No weapons, no drugs without a valid prescription. Do not miss your court dates, okay? All right, everything's going to be on your paperwork. I'll give you a copy.
Thank
Thank you. Ms. Jenkins? And where is Mr. Garcia's case? Let me do this real quick. Okay. No action. Just 1 second, okay?
No, you're okay. Take your time.
What was that court date, the May 21 at 11:30?
April 21st.
Okay, his next one.
Oh, it is, what is the order, right? Yours,
May 21, 11:30?
yes.
Okay, let's get Mr. Garcia in here after Ms. Jenkins, please. All right, ma'am, can I have your full name and your date of birth, please?
Kira Jenkins, April 7th, 2005.
Okay, thanks. You're here on a new case. You were arrested for 2 allegations of shoplifting. It's basically the same incident alleged to have violated the statute in 2 different ways, and each of those is a Class 1 misdemeanor. There is probable cause for those. I'm not appointing a lawyer for you because I'm going to release you today, and you don't get a lawyer appointed in this kind of misdemeanor case unless the state is seeking jail time, which down the road, if they are, they will ask that you have a lawyer appointed. So, not to overly complicate that subject, I'm not appointing one. You have the right to hire one at your own expense or to just represent yourself. Your arraignment hearing will be June 11th, which is about 2.5 weeks from now. June 11th, 1 in the afternoon in the Goodyear City Court. As I said, I am releasing you. Do not go to that or any other Target store while the case is pending. No contact with the witnesses there. That'd be the employees. Everything else is going to be on your paperwork, okay? And I didn't check no alcohol. I saw that you're like 19, but also that's illegal whether I check that box or not.
Yeah.
So, all right, if you step to your left, they will give you a copy of your paperwork. Thank you.
Thank you.
All right, and then Mr. Garcia, if you'll run back in. I just want to make sure we get this attached. Okay. All right, so we're just going to go back on the record real quick in number 3 on the calendar. This is Mr. Garcia, who I remember, because sometimes I make people say their name again. All right, so we did look at public access records, and it was very clear, thank you, is that, okay. It was very clear that what you were telling me was corroborated. It shows that you appeared on the 21st of April. The warrant was quashed. They gave you a pretrial hearing, the next pretrial conference of May 21. First it said 9:45, then they vacated that. So then what happened is, now I'm confused. Hold on a second. I want to make sure I give you the right court date. Because what they wrote is May 21 at 9:45. Then it says hearing vacated April 21. Okay, fine. And so then it says scheduling event generated for May 21 at 11:30 a.m. And then it says pretrial conference scheduled June 18th at 9:45 a.m. So actually, I'm just confused on when your next court date is. So you know what? I want to just reprint it and take out, because I like to tell people their next court date so that court can see that you were informed of it. It's a confirmation for them.
It's June
Honestly,
18th.
Okay, I'm going to delete my note about when your next court date is because I can't tell. I can tell that the warrant was quashed. So same decision. I just want to reprint my paperwork to not say that I gave you any specific court date because there's like 3 of them in here. So good for you. That was confirmed. So you do not have any bond owed in the Goodyear case. You are. What I did is I took no action. Well, I think that does. Yeah, I took no action. I was trying to make sure that it's going to clear out and the system's fine. So what it means is you don't have a court date. I just basically undid that we had a hearing because Goodyear shouldn't have done that. You can, if you want, take your booking paperwork to them when you go and see if you can get a day's worth of credit against whatever you might end up owing them in that case if you are convicted, because you're not convicted yet. But if you end up needing some credit for time in custody on that case, you can definitely argue that they should give you a day for this since it was their fault. Yes. But in any event, so now your bond total for the 2 cases is $550, okay? So we need to get that reprinted, and the officers will send it out to you. So if you go ahead and have the seat, we'll send out a copy. And you can leave them the other one that said that you had a bond. Oh, they didn't give it to you? Okay. Go ahead.
Just give it back.
All right, sounds good. Go ahead and have a seat. We'll try to make sure you have all your correct paperwork. All right, thank you. All right, Ms. Martinez, and then Darian Foster, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Laura Martinez, 12/14/94.
All right, thanks. You're here on a warrant from Arrowhead Justice Court. It's a drug paraphernalia possession case. It is a Class 1 misdemeanor, and you've already been convicted in this case. This is a post-adjudication, failure to comply or failure to pay. It issued September 12th of 2024. I looked at the case card in your case, which is just a little docket thing we can see for Justice Court. I don't see that this is a failure to appear warrant. It is a failure to comply or failure to pay. So I'm going to release you in this case. I show it was a page 2. Do you have other jail holds here? Did you get arrested on anything else?
It was just that. I was waiting for the Arrowhead one.
Oh, did you get released in something else and then this warrant hit?
No, I self-surrendered and then that popped up.
On something else? Okay.
The Arrowhead one popped up.
Are you about to serve a sentence or you're done and you're leaving?
I'm done and I'm
Okay,
leaving.
okay,
Yes.
great. I just want to make sure I wasn't going to mess you up by causing you, like if you just surrendered for a 60-day sentence, then I needed to do something else. But as long as we both think you should be out of custody on June 10th, I'm going to release you. Your court date in Arrowhead is June 10th, 2 in the afternoon. Go talk to them about what you owe. If you don't, that is going to come up as a failure to appear.
Okay.
And even though we might not give you as high a bond as we would if it was a pending case, we will give you a bond for failing to appear post-conviction. You have to go to court.
Yeah.
We're not here to help them collect money or get you to do classes. That's their problem. We are here to get you to go to court. So if you don't, you're getting a bond next time, okay? All right, if you step to your left, you get your paperwork. Thank you. All right, you too. Mr. Foster, sorry, Darian Foster.
Ma'am, so Garcia's still staying in custody, right?
He's got 2 cases with bond, right. And just the Goodyear one, no action.
No action.
Yeah, because that was a bad warrant. Hi, sir, can I have your full name and date of birth?
Darion Foster, 122197.
All right, thanks. Mr. Foster, you are here on two things, a new case and a probation hold. In the new case, you were arrested for criminal trespass of a residential structure. It's a Class 6 felony. There is probable cause for it, and I am appointing a lawyer for you. I'm also appointing a lawyer in your probation case because by policy, the probation department is required to file a petition to revoke your probation when you pick up a new felony arrest. So that is going to be filed between now and your next court date. I'm appointing a lawyer in probation court to help you. Your next court date in probation court is going to be May 29th, which is this Thursday at 8:30 in the morning. It's a revocation arraignment and possible disposition hearing. In the new case, your court dates will be in 2 weeks. So next week, you're going to go to probation court. The week after that, you're going to go to regular downtown court for the pending case. So the court dates are a status conference, June 6th at 8:30 in the morning, with a preliminary hearing June 10th at 8:30 in the same court. And I saved your case for last because I am actually planning to release you. That is not typical in a probation case. And I really didn't want other probationers to see me do it because then they would all think that they could talk me into it. It is very hard to talk me into that. What did talk me into that was reading the probation notes in your case, meaning that you had graduated to standard. You appear to have a job. It does appear to me that you actually do have a job. Most people lie about that, I think. But I think you do. I would like for you to keep it. I also don't think that even if you did the exact crime they accuse you of, that you need to go to prison. I don't think that it's even a likely outcome. It's a theoretical outcome, but I don't think it's a likely outcome because this is the sort of residential criminal trespass that a lot of people commit, not realizing it's a felony, et cetera, and it's something that I don't think very many people think makes you a danger to society. So that being said, I've weighed all of that. If this was a more serious crime, we would not be having this discussion. I would have just held you. But in my mind, in terms of the dangerousness of this type of felony, very low, even if you did it and you're presumed innocent. Also, you have actually been doing well on probation. Nothing in there suggested to me that you weren't doing well. And I do want to recognize that, encourage you to continue to do that. I considered an ankle monitor for you, but frankly, on this type of crime, I don't see the purpose of it, meaning this is not a random crime. This is an eviction situation that isn't, if this was a stranger's house or something, I might have at least thought of an ankle monitor, or maybe I would have just put a bond on you. But on these exact facts, with how well you've been doing on probation, I'm willing to just let you go continue to be supervised by your PO. Also, I think you'll have a strong motive to keep doing well, because the very best thing you can do for yourself, given your new problem, is continue to be doing very well on probation, because your probation officer will be in your corner. Your lawyer will have a ton of things to argue in your favor. You may end up, your lawyer will have arguments to make for a favorable resolution from the county attorney, meaning potentially a misdemeanor or who knows what. Like, your lawyer can only get a stronger case the better you do on probation. So I am literally trying to motivate you, because we don't see that many people doing well on probation. So it's nice to see people who are. In fact, I almost see nobody who's doing well on probation. We just see the people who are messing up. So I don't, even if I believe you did exactly what they said, I don't think you need to be revoked to prison. I don't think, you know what I'm saying? I don't think you're dangerous. So
Thank you.
still comply with your release conditions. Don't go back there. If you still have things there, you can do a civil standby. I gave you a civil standby, which means you got to call whatever agency has jurisdiction. Is that Phoenix? Tell them you need a civil standby. They'll want to see your paperwork to see that I gave you permission. They'll send a cop. The cop goes with you to keep the peace while you try to get your stuff. No weapons, no drugs without a valid prescription, no alcohol. You need to call your PO within 72 hours of release. And if you're smart, you'll call them today and thank them for actually making notes that show that you were doing well. Because, your PO was reflecting that you were doing well, and I think they were satisfied with your performance and I think probably hoping to help you get off probation soon. I forget what you're even on probation for. It's a 6, though, which to me doesn't trigger a high-risk presumption. Endangerment, DUI, that's right. So as long as you're staying sober, you're going to work, you're doing what you're supposed to do, is certainly my hope, Mr. Foster, that this case, even if you are convicted, does not derail your progress. So, hang in there, keep being good. Don't be discouraged by this. Go to court, deal with your case, okay? You're also entitled to fight this case.
Thank
So,
you, ma'am.
good luck, sir. If you step to
Thank
your
you so
left,
much.
get your paperwork.
Thank
All right.
you.
Call your PO when you get out.
Thank you so much.
Because, yeah, no problem, because this is happening because you did well on probation. You're doing well, okay?
I've been trying hard. Thank you.
Yeah, I can tell. All right, good luck, sir. All right, Ms. Armstrong? Oh, no, she's a house call. So let me do that real quick. I'm going to get the base for the house call in a second. All right, let's see. All right, Mr. Shane, are you the last person in there?
Yes.
Okay, you go ahead and come in, please. Okay, I just can't see the entire room. Okay. Yes, right at the podium, please. All right, sir, may I have your full name and date of birth, please?
Nikander Shane, 11/18/1980.
All right, thank you. You are here in a new case. You're arrested for 2 counts of sexual conduct with a minor under the age of 15. Those are Class 2 felonies. Surreptitious photography of a person in a state of nudity, Class 4 felony. Unlawful viewing, taping, or recording a person in a state of nudity, that's a Class 5 felony. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your next court date is going to be a status conference May 30th, which is 1 week from today at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be June 2nd at 8:30 in the same court. And in your case, the state recommended a bail of $500,000 cash only. In this case, the court is intending to set bail in the amount of $250,000 cash only. The reasons for that are set forth in my written order, but they include, among them, that a person accused of these crimes does face very significant and lengthy mandatory prison terms. In your case, the allegations of the sexual conduct, they date back some years, and this court is not aware of when the law changed. So this court is moving on the presumption or acting on the presumption that you face at a minimum mandatory prison terms. But there was a change in the law at some point in the last 5 to 7 years, I think. I did not look it up. That takes legal research to very significantly increase the penalties for these crimes up to and including a potential life sentence based on the ages of the children and the position of trust, and that it is more than one child alleged. So this court has considered that you face at a minimum, even if you're accused of doing those crimes prior to the change in the law, you face decades, potential decades of mandatory prison for this. And that is enough to make anybody flee. But in addition to that, this court believes that there is a significant weight of evidence alleged against you. You have ties to another state. There are indications you may not voluntarily surrender for arrest, much less a guilty verdict. And the court is very concerned about a propensity for sexual victimization of children in the community. So for all of these reasons, this court believes that $250,000 cash only is the least amount necessary to meet the purposes of bail under Arizona law. If you post that, you must by law be on an electronic ankle monitor because you are accused of sexual crimes against children. So you have to be on an ankle monitor. For that reason, and because the court believes you do pose a very significant flight risk, you may not step foot outside Maricopa County without an order from the court, meaning whatever business you're doing out of state, you may not travel outside of this county without a court order because the electronic monitoring is only feasible inside this county. So, absolutely no contact with the alleged victims, nor any of the witnesses in the case, and it looks like your third child is a material witness in this case. This court also finds there is a reasonable possibility that you may engage not only in witness tampering, but that the third child could potentially be a third victim, and that his safety dictates that, at least for this moment in time, you do not have any contact with any minor child that you may have. And you may not have any contact with anybody else's minor children, meaning you don't have a legal right to have contact with children in a criminal case, except your own. I do order you do not have any contact with any of your own minor children, nor the witness in the case. I think one of your children may be an adult, and that may be the witness. No weapons, no drugs, no alcohol. You must obey any order of protection that is served on you. If you are out of custody, you may not live where they live. You must find an alternative residence and provide proof to pretrial services within 24 hours. although you can do a civil standby to collect belongings. But you have to post the $250,000 first, and then you would go out on an ankle monitor. Everything I just told you is going to be on your paperwork. If you step to your left, he's going to give you a copy of that.
So there's no way I can travel to my job?
Correct. This court forbids you from leaving the county except with an advance court order. So that means you have to go to the trial court. You have to provide them with information about it. You have to assure them to their satisfaction that you intend to return, and then they will decide. So you will have a lawyer appointed. Your lawyer can help you with that kind of a motion if and when you post the bail. Everything's on your paperwork if you step to your left. All right, so, officer, I have a house call from Maida Armstrong. Did she get isolated as a potential risk of danger to herself or others?
No.
Okay.
She's unable to function in GP.
All right, well, not to put too fine a point on it, but I find that people who are listed as unable to function, that they could pose a risk to themselves or others if they are physically brought to court because they're not functioning and they'll distract the officers, and in a group setting like this, that is not safe on an overall basis. I have a note here saying she was reportedly disrespecting officers, which I take to mean not following directions. Do you have an indication of that, or is it just this UTF business?
I believe it's as well.
Okay. All right, because I don't love people just writing UTF and then giving no other information. But if I have information that they've been isolated as a potential risk of danger to themselves or others, that satisfies me. So, in any event. Again, not to put too fine a point on it, I'm going to go conduct Maida Armstrong's initial appearance in-house, in person, immediately following this recording. She was born 9/17/86. I'll advise her she got booked on a new case and a probation hold. In the new case, she was arrested for shoplifting as a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for her, giving her status conference court date of May 30th at 8:30 with a preliminary hearing June 2nd at 8:30 in the downtown Superior Court. And she's also on probation for robbery, a Class 4 felony, and I'll let her know the probation department's going to file a petition to revoke her probation, and she'll have a lawyer appointed to represent her on that. Her revocation arraignment, a possible disposition hearing will be set for May 29th at 8:30 in the morning in the downtown probation court. And right now, the court is inclined to set bail in each of these two cases in the amount of $2,500 secured. With written release conditions, I will go over with Ms. Armstrong. If anything changes after I do conduct these initial appearances in-house, my final written order will reflect the court's ultimate decision in the case. It is not this court's intention to update this recording. All right, then we're going to stand at recess until 2 p.m. this afternoon.